What is a trust fund? A trust fund refers to assets held inside of a trust. And a trust is simply a legal tool, a legal document, used to hold property for another party's benefit. The fund in this context consists of the assets held inside of the trust according to the trust's terms. Hi, I'm the business guy, and I've been in the trust formation and asset protection business since 1991. Our company started in 1906. We have attorneys on our staff who are experts in trust formation. So if you have questions, please give us a call. In addition, if you like this video, please click like below and comment below as well. I do answer questions. Plus, please click the subscribe button below as well. So when other videos come out like this, you'll be notified. When the term trust fund conjures up an image of high net worth individuals, middle class people are increasingly turning to trust funds so that their estates can avoid probate. And that's the legal process of transferring assets upon death. And a trust can avoid all of the lawyers and judges and legal fees, and so they can better control how your heirs receive the assets, and they receive more of your assets upon your passing. Now, setting up a trust fund is one of the best ways to ensure the financial security of your loved ones. And this is because a trust can reduce estate taxes, eliminate probate, make investments, and schedule monthly distributions to yourself and your loved ones. Now, most importantly, certain aspects of the trust can protect assets from lawsuits. After all, if a greedy law firm plunders your wealth, the prior points are moot. Moreover, a trust can provide these benefits during your lifetime and long after you have passed, unlike a will. So here we will discuss the advantages in detail. And the bottom line is, no matter what your net worth, you can create a trust fund to provide financial security for yourself and your loved ones. Now, incidentally, you can even use a trust to protect them from themselves. That is, if you fear your heirs may not handle your bequests responsibly, you can set up the trust fund to address these issues, such as making monthly distributions rather than having them blow through a big lump sum by buying a fleet of Ferraris in every color. Thus, with a trust fund, you can distribute your wealth and your assets the way you would like to distribute them. A trust fund baby, you may have heard of this term. A trust fund baby refers to a person, especially a younger individual, for whom a trust was established that provides sufficient income so the individual does not need to work for a living. Now, parents or grandparents typically establish such financial arrangements in trust that provide for the living expenses of a child or grandchild or other individual. Now, the stereotypical image of a trust fund baby is that of an individual living a high society existence without having to put forth the entrepreneurial exertion required to produce such a lifestyle. People envision the individual driving exotic cars, jet-setting around the globe, and going on exotic vacations. Now, in truth, according to thecut.com, those who receive trust funds represent fewer than 2% of the U.S. population. Moreover, the median amount received, they continue, is only about $285,000. And most, if not all people who are beneficiaries of trust funds still need to work. And these trusts simply provide a lump sum payment or ongoing supplemental incomes. Now, those who leave behind substantial estates often insert a spendthrift provision in their trust. That is, the trust appoints a trustee who limits the trust's financial outgo. And those with the forethought often structure this arrangement to prevent young people from spending foolishly and burning through their inheritances. Here are some most popular trusts. Among the most popular tools to create trust funds are the inter vivos trust, or living trust. We call these tools revocable trust. This means the owner can make many sorts of changes to the trust during their lifetimes. This includes changing or adding beneficiaries and moving assets in or out of the trust. And once the trust owner dies, however, the living trust becomes irrevocable. Its provisions cannot change at that point. Now, a living trust does not hold significant income advantages, it can in turn have significant estate tax advantages for the trust fund recipients. And that is because the trust can divide assets into two subtrusts, for example. Subtrust A is for the first spouse. Trust B is for the second spouse, for example. Typically, it works this way. When one spouse dies, the other spouse has full access to one of the subtrusts. The surviving spouse has access to the income that the other subtrust fund provides. When both die, this arrangement doubles the amount the heirs can receive estate tax-free. It's kind of like the heirs have received income or lump sums from two different people instead of one person, so it doubles the amount they can receive. Moreover, when you set up a living trust, your estate does not go through probate. And again, probate is the legal process of proving that a will is valid. And as we said, this process typically involves lawyers, i.e. legal fees, and a judge must approve the probate process. Now, consequently, there are often substantial probate fees that are due as part of this process. Plus, probate is a very public ordeal that lays assets out in the broad daylight of the public record, so everybody can see the assets. Thus, people often turn toward these type of trusts to protect their privacy. They use them to reduce or eliminate estate taxes and probate fees, and in addition, they use them to speed up the asset distribution to beneficiaries. Now, how trust funds work. Now, for financial and estate planning purposes, several types of trusts are available, but the two of interest to most people are the aforementioned inter vivos trust and the testamentary trust. While similar to an irrevocable trust, a person's will creates a testamentary trust fund. Therefore, it does not exist prior to the individual's death. A grantor, also known as a settlor, is the person creating and funding the trust fund. Now, the individual also determines the trust management terms. The trustee, which is either an individual or financial institution, is the entity responsible for overseeing the trust. Now, with many revocable trusts, the grantor is also the trustee. The settlor establishes the trust fund for the beneficiary. The beneficiary does not own the trust assets. Rather, the trustee manages the trust assets to the best interest of the beneficiary as per the trust agreement. Now, the grantor names the beneficiaries and the trustee. Now, beneficiaries receiving money from a trust account will find how often the money is distributed depends on the stipulations and the terms of the trust. And beneficiaries might receive all of the proceeds in one lump sum or receive, as we said, payments on a monthly, quarterly, or annual basis. More about living trusts. Now, living trusts are set up during the grantor's lifetime, and typically the grantor also is the trustee, so they may manage the assets. Professionals often design revocable trusts to end with the grantor's death, with assets to be distributed to beneficiaries. While the grantor lives, he or she may buy and sell trust assets and move them in and out of the trust. The grantor reports that all trust income on his or her personal tax returns. Now, when the grantor dies and the trust becomes irrevocable, someone values the assets for estate purposes as of the grantor's date of death. Now, let's talk about irrevocable trusts. Oftentimes, we establish trusts for clients that are irrevocable from the start. Now, most settlers establish these instruments to keep creditors away from the assets. In addition, these trusts can significantly lower estate taxes. Now, with irrevocable trusts, the grantor transfers assets into the trust and can receive income or lump sums according to the terms of the trust. Certainly, certain types of irrevocable trusts must file their own tax returns each year. Others simply flow through to the tax returns of the settlor without separate filings. Now, when a person sets up an irrevocable trust without naming themselves as a beneficiary, assets in such a trust are not part of the grantor's estate. That is, it's not part of the grantor's estate when they pass or when they're alive for that matter. Some irrevocable trusts are quite detailed, and unlike revocable living trusts, they provide substantial asset protection benefits. That is, when a lawsuit strikes, the trust can shield the trust fund from legal attacks, and the irrevocable trust often continues beyond the grantor's death. And as a result, it may continue making distributions to certain beneficiaries, and in these situations, the tax code considers these distributions as taxable income payable at the beneficiary's rates. Now, the strongest asset protection trusts are the Cook Islands Trust. The Cook Islands are south of Hawaii, and the Nevis Trust, N-E-V-I-S, and that is an island south of Florida in the Caribbean. The domestic courts do not have jurisdiction over trustees in these jurisdictions. In fact, we use our law firms in Cook Islands and our law firms in Nevis to serve as the trustees. Plus, these two regions do not recognize foreign judgments that might attempt to attach such trust funds. Now, beneficiaries and trust fund beneficiaries have some rights when it comes to trust funds, but understanding the provisions of the trust is critical. If a beneficiary does not understand how the settlor originally designed the trust and how it operates, he should contact an estate planning specialist. A specialist will check to make sure the process is carried out correctly and check to make sure the trust is operating on the terms of the trust. Current beneficiaries of the trust may request in writing an accounting of the trust from the trustee, and these beneficiaries should receive the payments granted to them by the terms of the trust. Now, when a beneficiary does not feel the trustee is acting to their best interest, it is possible to file a petition with the court for trustee removal, so you can replace the trustee with another one. The beneficiaries receiving money from a trust fund account can collect their funds as per the terms of the trust. For example, the beneficiary may receive all the funds in a lump sum, as we said, or payments that are set on a monthly, quarterly, or annual basis, as stated previously. Here's a conclusion. A trust fund is simply assets within a trust. That's what a trust fund is. There are a variety of different trusts that hold such funds. The best step is to contact a professional who can discuss your particular needs. And there are attorneys on our staff, as we mentioned, and there are numbers that you can call on this page and on this screen. In addition, you can set up and complete a consultation form on our page, as you can see on the screen, for more information.